Right, okay. Privacy issue. I'm going to go. Hi, my name is Ken Vercammen. I'm an attorney in Edison, New Jersey, and we periodically do educational programs and workshops. Tonight we're talking to the Sayreville community and the surrounding community. So, I usually start about, people often say, like, I'm at a cocktail party or, events like when the state wasn't closed. Well, why do I need to have a will? Doesn't everything go to my spouse? He goes, well, maybe not, but that even if you're married, the other person's not going to live forever. So there's always reasons why you want to have properly done documents, because if you leave no will or your will is declared invalid because it was improperly prepared or not admissible to probate, the procedure to distribute assets becomes much more complicated. It would require, if there's kids, all the kids to sign a renunciation affidavit in front of a notary. If all the children do not sign a renunciation affidavit in front of the notary, then a complaint order shall cause has to be filed in the Superior Court. Families spending over $3,000 in court costs and legal fees. Certainly the preparation of a will for under $400 would eliminate those costs. Number two, if there's no will or it's not, these crappy do-it-yourself things, then there's additional expenses to be incurred called the surety bond. And I see these cheap things online don't have the magic words. It says no bond required, so that's an additional grand cost. Number three, if there's no will, state law determines who gets assets, not you. And more people are saying, why should I give it to my kids when I can give it to grandkids, or I'll give it to the people who I like. If someone doesn't call me on Mother's Day and wish me happy Mother's Day, why should they get anything? If someone has no close blood relatives, the state of New Jersey gets money. Who would want the state of New Jersey to get money? But more importantly, if there's no will, it often causes stress, aggravation, fights between family. More people would say, hey, I'd rather have my family or charities get it than the state of New Jersey. You want to prevent a crazy family member from mucking everything up. So the whole idea is, if you do planning, it makes everyone's life easier. And you also want the idea that you cannot have tax. Sometimes you want to reduce your estate taxes. Because there's a proposal by the in the federal to put back on the federal estate tax. Okay, so now let's talk a little bit about how the process is done. Well, certainly, you would want, if something happened to you, you'd rather have your families get and your friends get things. But think about, who don't you want to get assets? If someone has minor children, who would not be the best choice to raise minor kids? Certainly, if 18-year-olds, 20-year-olds get money, they wouldn't invest wisely. They'd go to Seaside and play games. So, also beware of online documents that that aren't prepared by professionals. I mean, it's kind of like trying to do your own electrical work. If you watch a YouTube video and try to do your own electrical work and your house burns down, that's your own fault. You try to do your own plumbing work and the toilet backs up on the second floor and goes throughout the house. Well, you probably should have hired a professional. And the same thing sometimes with estate planning. So we say, listen, have a self-proving will, make sure it says no bond required, and just don't assume. Now, we also, most attorneys have made it easier for people because, ever since, COVID, when things closed down, because how can I get stuff done? Well, it's easier because instead of you having to take off a day of work and go meet with the attorney, I get to go over stuff, the attorney will email you a questionnaire. You type in who's executor 1, who's executor 2, who's getting your things. The attorney talks to you. People can even retain the attorney by credit card online, send in a check. We prepare the documents. We send them to people. They print them if there's no errors, and we give easy instructions on signing at the UPS store. So there's no reason why people should put off stuff. anymore. We try to make it easy. Okay, so in the will questionnaire the attorney sends out, you're gonna. We used to have it handwritten. Now handwriting is stupid. They're gonna type in who's getting their things, and then they go into who's going to be executor 1, who's going to be executor 2. We don't want to have co-executors. There's a reason why there's only one president of the United States. So an executor 1, executor 2. Even if they were twins living together, co-executors create twice as much work. We want to make things easier, not more difficult. Now, the will directs typically who gets your assets that don't have a direct beneficiary. A will cannot change that. So even though we ask some general questions about what real estate you have, what assets you have, certain assets pass by title, not by will. So an example is a house. If it's owned by husband and wife, that's tenants by the entirety. That goes directly to the survivor. The will can't change that. If you have bank accounts, POD, payable upon death, joint tenancy, automatically goes to the survivor. The will can't change that. Certain assets pass by contract. IRA, 401k, life insurance, annuity. If you have a beneficiary, the will can't change that. So then, in your in the form you're given by the attorney, you're basically putting down who do you want to get your stuff, and a lot of times, hey, who don't you want to get your stuff? Some people have specific bequests of assets to a family member. Some of the ladies say, hey, I want my jewelry going specifically to my granddaughter because they know if it goes to their son, he'll say, hey. The son will bring the cash for cold. What do you give me for this junk? Some people want a specific amount of money going to a charity. Someone might say, hey, I want $10,000 to go to, St. Mary's South Amboy. Someone might say, I want $10,000 to go to the Hibernians or Ancient Order of the Shillelagh. But also you want to have a clause that says, no one gets any money until they're at least 21 because 19-year-olds never do smart things with money. Now, some people minor kids. Well, it's a good idea to set up a trust to hold the money for those minor kids so they don't get it outright. So there's someone who is in your will. You want to have a clause if there's minor kids. Hey, who would hold the money until whatever age you select, and then who would be the guardian? So think of the trustee holds the money. The guardian holds the kids. It's difficult for some people. I can't decide. No, it's easy. Let's see. If you couldn't come home for the next week, who would you trust to watch your kids? There's not too many people on the planet that you would trust to watch your kids. So who don't you want as in the will? Now, also I mentioned make sure that you have what's called a self-proving will. Under the old law, it required one of the two witnesses to go to the surrogate's office or sign paperwork with the surrogate saying you were a witness. The new way, you don't have to locate witnesses when it's done by most attorneys nowadays. But just don't assume. We're helping a couple people probate wills where it was done the old ways because it was a small law office and they didn't have enough witnesses to do self-proving wills. Also, I mentioned beware of these cheap online things that are not self-proving because then the family got to locate witnesses down the road. Logistically, what the attorneys do, they prepare the documents, and more people through their work have what's called kind of legal insurance where it pays for wills, powers of attorney, and living wills. So some of the main companies in New Jersey are MetLife, Hyatt, ARAG, and another company's coming in legalese. So sometimes you talk to your employer. Now, a will that's done by an attorney in New Jersey is valid now. It's valid in 10 years. It's even valid if you go to another state. Sometimes what's valid though, we say if you move to another state, you may want to discuss it once you unpack with that with an attorney in that state to inquire, hey, is this still good for me? We do recommend have attorney be signed every 5 years. Now going back to people sometimes say, I wanted my kids joint. No. There's a reason why the car only has one steering wheel, one captain of the ship. Some of the clauses that you want to go into the will, debts and taxes paid, specific bequest, distribution to spouse. Sometimes instead of going outright to a spouse, a trust for the spouse. So if it's within the will, it's protected for Medicaid. Sometimes for the kids could have drug or financial problems. So then sometimes we set up a testamentary trust within the will for kids. But the whole thing is get it done. Don't put it off. One gentleman goes, "Oh, I want to read more up. I want to read up." I go, "Sir, you don't need to read anything up. When I need a knee surgery, I didn't want to even read about knee surgery. I go to the doctor. Doctor, you've done this before?" He goes, "Kenny, I could almost do this in my sleep." So that's why I tell people not to brag. But I wrote a book on this for the American Bar. I do this all the time. I've done your reading for you. Some people ask me about trusts. Now, there's two types of trust. One's a revocable trust. Now, my mother-in-law, called me, said, "Oh, I want to come in and get a trust." And I asked her, was she watching Susie Orman? She said, yes. I goes, Susie Orman is right if you live in New York, California, Florida, where probate is very complicated. But New Jersey, probate's easy. It's the easiest state. So I ask people who want to have a trust, why do you think you need to have a revocable trust set up and spend $3,000, $4,000, $5,000? Probate in New Jersey is easy. It's inexpensive. A revocable trust does not protect assets. Some people were concerned about making it easier. Well, listen, if you're going to set up a trust, you're spending all this money, then you're putting the money. Things have to be retitled, so the houses have to be owned instead by the trust. For the purpose of Medicaid has to be an irrevocable trust, so you can't be the trustee. You can't own it anymore. Now, a will does not need to be updated if your beneficiaries and executors remain the same, but look to see who your executor is. If your executor is now 85 years old and can't drive, maybe it's better if it's someone who's younger or can't get that. Some people have kids that are special needs. Well, those are special needs trusts. Some people want to have their house transferred to a kid. Well, before you think about doing that, make sure you put a life estate in. Logistically, we prepare the documents, we send them out to people. Only the original will can be admitted to probate. A photocopy cannot be admitted to probate. It's important that your executor can get to the original will. So that's why you don't want to have it in a bank safe deposit box, because you can't get it. After your will is done, it's also a good idea to prepare what's called a letter of instruction to family, etc., advising where your stuff is at, especially if your executor doesn't live with you. And some people even prepay for funerals. This way, it takes the pressure off the family. I remember, I'm not an old guy, but I said go to a funeral home. I goes, okay, I want no big long mass. I don't want to be buried. Just a cremation. You can throw the ashes in Lake Scranton and the ocean by Belmar and be done with it. But again, trying to make it as easy as possible. Now, so the next document we're going to talk about is the power of attorney. But before I jump into the power of attorney, I always add that if someone is nice enough to listen to our program, if they contact us within 30 days, then the office waives the $200 consult fee. Otherwise, we do charge a $200 consult fee. Okay, now let's talk about the next document is the power of attorney. What the power of attorney, a will takes care of assets if you pass away. What the power of attorney is, you're giving power to a spouse, family member to be able to make sure that your bills are paid and things are taken care of now or if you become disabled. But it's important because you want to have these documents now. We get calls all the time. Oh, I need to get power of attorney over Mom, Dad, or Uncle Joe. Well, you can't do that. You can't get a power attorney over someone. They have to affirmatively contact the attorney. So, and have it done. And say, if someone can't say to us, "This is what I want," well, legally I can't do it. So again, it's better to do these documents ahead of time and have them in your file. Now, also another reason why you want to stay clear of cheap things online is because a lot of the banks weren't like saying, "Oh, well, we're not going to recognize that power of attorney wasn't done in our form," or so. New Jersey legislature came up with a law that said if the power of attorney references the New Jersey statute, they had to honor it. However, that means that it has to make reference to Section 2 of PL 1991 C46. C46:2B-11, and these cheap online things don't say that. We also revised our powers of attorney now to have a HIPAA authorization, to have a life plan giver authorization. We also recommend a new power of attorney be signed every 5 years, or if names change by your kids, daughter gets married, name changes, people's addresses change. Otherwise it becomes more complicated when they try to use the power of attorney, and the bank goes, well, you showed us your ID, it has a different name, a different address. Okay. The power of attorney is effective either right away or only upon disability. Almost everyone makes it effective right away, because if it's effective only upon disability, you have to get detailed notes from doctors saying the person is disabled, and then go and try to prove it to the different banks. One of our clients, he go, nice guy, goes, "Kenny, I'm a carpenter. I don't understand this, this legal terms, durable power of attorney, springing power of attorney." Goes, "Explain it to me in carpenter terms." I go, "Okay. If it's effective right away, your son who is the agent can still owe your money right away. If it's effective only upon disability, he has to wait for you to become disabled before he steals your money, knowing that you trust your son." He goes, "Oh, I trust my son with my life." Okay, so make it. I recommend that you make it effective right away. No reason to put things off. Now, with the different documents that you do, what I do recommend with the power of attorney is after you sign it, you have it scanned and sent to your family, well, Agent 1, Agent 2, and then it's a good idea also to have it sent to your financial advisor, your bank, your life insurance people. That way, they have it in their records, so if it's ever needed to be used, it's easy for them to see it, and there's less of a hassle. If the bank continues to give you a hard time, then hey, then we're going to file a complaint with the Department of Banking. They can't just say we're not going to do it if it follows the New Jersey law. All right, so now. The next document we're going to talk about is the Living Will Advance Directive. That's the document where someone's in a coma, irreversible condition. There's no hope for them. You're giving instructions to hospitals, doctors, where you say, "Hey, listen, if there's no hope for me, I don't want to be kept alive on tubes and things like that." So people remember the Terry Schiavo case, Karen Ann Quinlan case, and therefore, the document living will really isn't for you. It's so your family is not put in that horrible position where a doctor says, "Hey, should today be the last? Should we remove life support today? Should today be the last day? Should the person be, die today?" I remember a doctor asked me that question. I goes, "Geez, doctor, I feel bad." Now, you know what the right decision is for someone who's 92 years old that's never going to regain consciousness or open their eyes. But you hate to be the person to say, "Okay, yeah, let's end their life right now." So, again, you want to sign the living will, and then after it's signed, again, you scan it, you send it to family, and you send it to the doctors. In the power of attorney, the first section, and we took language from the medical society, so doctors are familiar with it. It asks fluids and nutrition, yes or no. Hey, probably 80% of the people say there's no hope for me. I don't want to be no feeding tubes, no fluids and nutrition. The next section deals with artificial machines. 99% of people say no. And we also put a HIPAA authorization in our living wills because the laws are always changing. The last page, we also have an organ donor, and I always recommend people sign the organ donor card. Now, both your typically most the person's the same person who's your executor, your agent, the power of attorney, the agent, a living will. But we do recommend that our rule of thumb on being the executor is, can they drive to the surrogate's office? Can they walk up a flight of steps? Because if you can't drive and go to the bank, it becomes much more difficult to do. So we've went over wills. We went over powers of attorney. We went over living wills. If someone passes away, probate in New Jersey is not that complicated. So basically, the executor, what we do is we help them what's called probate the will, submit it to the surrogate's office as forms and paperwork we fill out, and then we prepare the inheritance tax return. New Jersey, there's no inheritance tax that's due if it's going to children, spouse, grandchildren, stepchildren, but there's still a return that has to be filed, and otherwise it's a lien on the property. So, hey, we try to make it easy. We email people a quick probate questionnaire in layman's terms, and then we try to do as much to help people out as possible. Is there any real estate? Okay, we got to get a tax waiver on that. Then the property gets listed for sale. The executor opens up an estate account, obtains a tax ID number, pays the bills, and then at the end, once the bills are paid, we're getting ready to distribute the money. The executor typically provides an informal accounting, and easy as give them copies of the bank statements. Hey, this is what came in, this is what went out, this is what's left. You're going to get approximately X amount. The attorney prepares something called a release and refunding bond that gets all the beneficiaries got to sign a release or refunding bond. Otherwise, the executor has to go through an expensive formal accounting. It's a good idea if someone's an executor, keep people posted, send an email out every 2 weeks, 3 weeks, just to, keep everyone informed what's going on. Just like, we try to advise everyone, hey, there's a New Jersey inheritance tax, and that got to be followed. Typically we do these programs for about 25 minutes, and if anyone has any questions, we can